Good afternoon, everyone. My name is Rosemary Langford, and I'm a professor at Melbourne Law School and director of the Corporate Law and Financial Regulation program at the Melbourne Centre of Corporate Law. Importantly, let me first say that Melbourne Law School acknowledges the peoples of the Kulin Nations as the traditional owners of the land on which our school stands. And as a school, we pay respects to elders past, present, and emerging. We're delighted today to partner with the Australian Law Reform Commission in bringing in this webinar on regulation of crypto assets and DAOs. As we noted in the invitation, the webinar will provide an update on regulatory developments in Australia and overseas and explore the direction of future reforms. We're fortunate today to have a panel of experts to talk about the issues. I note that there were detailed bios provided with the event information, so I'll just briefly introduce each of them in the order in which they're speaking. Our first speaker is Andrew Godwin, who's team leader and special counsel at the Australian Law Reform Commission and also a principal fellow here at Melbourne Law School. Our second speaker is Lawrence White, who's a Melbourne-based barrister and consultant specialising in financial regulation and digital assets topics. Just to clarify, Lawrence is speaking in his personal capacity and not on behalf of any client. Joni Pirovic is a passionate advocate for Web3 innovation and DAO-first thinking, having founded LawFi DAO in July 2022 and with a wide-ranging legal practice. Finally, Miles McGregor-Lowndes, OAM, is Emeritus Professor at Queensland University of Technology and founding director of the Australian Centre of Philanthropy and Non-Profit Studies. In terms of the focus of each of our presentations this afternoon, Andrew will set the scene by clarifying the terminology and taxonomy and identifying the challenges faced by regulation. Lawrence is then going to speak about the regulation of crypto assets in a global context. Joni will then talk about the standards necessary for legal recognition and limited liability for DAOs, drawing on her experience as a creator of LawFi DAO, which I understand involves a self-regulatory approach to the regulation of DAOs. Finally, Miles will discuss DAOs and the non-profit sector, and this is a sector where DAOs have already generated a significant amount of interest. We will have time for Q&A at the end of the session, so please feel free to ask any questions via the Q&A function. Please accept my apologies in advance if we don't get time to answer your question. We'll do our best. In this respect, I would note that we're planning to hold more webinars on these topics in addition to a longer workshop that will take place later in the year. At the end of the webinar, we're going to conduct a poll to ascertain your interest in these future events and also to ask you the topics that interest you most. Our presenters have agreed to make their slides available and we'll put them on our website. And as you know, the webinar is also being recorded and will be made available via the website. I know there are a number of people who couldn't make it this afternoon. Finally, let me just make the usual disclaimer that nothing in this webinar constitutes legal, tax, financial, or accounting advice. The content is general in nature and doesn't take into account any specific circumstances. So without further ado, let me now hand over to Andrew Godwin. Thanks, Andrew.
Thanks very much, Rosemary. And thanks to Melbourne Law School for the invitation to join this panel. As many of you would be aware, this is a very fast-growing area. At the ALRC, we covered many of the issues concerning the regulation of crypto assets in a background paper that we issued last year on new business models, technologies, and practices. The purpose of that background paper was primarily to consider the issues within the context of our current inquiry into corporations and financial services legislation. However, we were keen to engage with and contribute to the general discussion concerning the issues, so it's great to have the opportunity today. As Rosemary mentioned, what I'd like to do with my comments is to set the scene for the comments from the other panelists and provide a conceptual framework for understanding crypto assets and decentralized autonomous organizations. It's very important, I think, to be clear about terminology and taxonomy. Taxonomy being the way in which things are classified for regulatory or other purposes. I've often thought that it's very difficult to regulate something if you don't know what it is or how it works. And so what I'd like to do is to engage with the token mapping consultation paper that was issued by Treasury a couple of weeks ago and the approach to taxonomy suggested by Treasury in that paper. So, as noted by the consultation paper, token mapping is about identifying the key activities and functions of products and mapping them against existing regulatory frameworks. There's no doubt that crypto assets and crypto markets are becoming increasingly relevant in Australia and overseas. Treasury's consultation paper notes that over 1 million Australians are expected to include crypto assets on their tax returns in the financial year ending 2022. It also notes that there has been huge volatility in the crypto assets market and that since 2021, the crypto asset markets have lost around 63% of their value. The crypto asset markets have an impact on the broader financial system and financial stability, particularly as mainstream participants such as banks and investment funds get involved in the markets. There are also ongoing concerns in relation to market confidence and the need to maintain market confidence, particularly after the collapse of various intermediaries. These concerns have highlighted the perceived need to strengthen the regulation of intermediaries, such as cryptocurrency exchanges. It's often suggested or implied that crypto markets are not regulated in Australia, but in fact they are regulated by financial services law, and where financial services law does not apply, by general consumer protection law. The critical question, I would suggest, is not whether crypto assets should be regulated, but instead whether they should be regulated in a more direct or bespoke manner, and if so, what that might look like. In this regard, it's interesting to note that jurisdictions around the world have differed in their approach to regulating crypto assets. While some jurisdictions have revised their existing regulatory frameworks, others have adopted bespoke regulatory frameworks. An example of the latter is the Market in Crypto Assets regulation in the EU, MiCA, which was approved by the European Council in October last year, and I understand is still pending approval by the European Parliament. There are two questions that are essential to the challenges confronting regulation in this area. The first is, what are crypto assets? And the second is, who's responsible if things go wrong? And that question is particularly important from a consumer protection perspective. So let me start by discussing the definition of crypto assets. The Treasury consultation paper that was issued a couple of weeks ago appears to move away from adopting a granular or context-specific definition of crypto assets towards the use of a high-level taxonomy that focuses more on function than on the label that might be used. Previously, for the purposes of its consultation paper on crypto assets secondary service providers, for example, Treasury defined a crypto asset as, and I quote, a digital representation of value that can be transferred, stored, or traded electronically. Treasury also noted that crypto assets use cryptography and distributed ledger technology for their operation. This is consistent with definitions adopted by others, but as I mentioned, the recent Treasury consultation paper on token mapping adopts a more high-level functional definition. And as I'll explain later, I think that makes sense, at least in the context of financial services. Treasury's taxonomy relies on three key concepts: tokens, token systems, and functions. So tokens are referred to as physical or digital units of information. A token system is a collection of steps involved in performing a function, and a function can be any benefit that is provided by the token system to a token holder. So when this approach is applied to crypto assets to determine whether they fall within the financial services regulatory framework, you get the elements as outlined on this slide. As noted by Treasury, this is a two-part question. The first, is the token system a facility under Chapter 7 of the Corporations Act? And secondly, is the facility one through which a person does any of the general financial functions, such as making an investment or managing a risk? If the answer to both questions is yes, the facility is a financial product, and that's all in line with the functional definition of a financial product in Chapter 7 of the Corporations Act. Treasury further proposal a high-level taxonomy for the token system under which crypto assets or services can be grouped. Let me explain this diagram, which I put together based on the taxonomy adopted by Treasury in its consultation paper. Token systems, namely the collection of steps involved in performing a function, are broken into two categories: intermediated token systems and public token systems. Under intermediated token systems, you have both crypto asset services and intermediated crypto assets. An example of the first one would be a cryptocurrency exchange. An example of the second one is exchange traded funds. Under public token systems, the reference to network tokens would include cryptocurrencies such as Bitcoin, and the reference to public smart contracts includes smart contract protocols and tokens that are used in the context of decentralized autonomous organizations, which I'll talk about shortly. So what about the second question that I posed in relation to crypto assets, namely who's responsible if things go wrong? One of the reasons why the current financial services regulatory framework in Australia already contemplates crypto is that there is a functional definition of financial product in Chapter 7 of the Corporations Act, and also quite an expansive definition of financial service. On that basis, where a crypto asset constitutes a financial product and where an activity in relation to crypto assets constitutes a financial service, the financial services regulatory framework will apply. Even if the financial services regulatory framework does not apply, the general consumer protections in the Australian consumer law, including the prohibition against misleading or deceptive conduct, will apply. Treasury has stated that the reasons why they have suggested a high-level taxonomy for crypto assets and token systems is that the possible functions of crypto assets are very broad. And I think that makes sense when compared with the, if you like, the shopping list approach that has been adopted in other jurisdictions, where distinctions are drawn between different types of token and regulation is designed accordingly. I think that type of approach is problematic and involves certain inconsistencies and the risk of regulatory arbitrage. One question that comes to my mind, however, is how the taxonomy deals with multi-function crypto assets. If, for example, a crypto asset has multiple functions, one of which is to operate as a financial product, or if it has potential functions where the realization of that function depends on the intention of the token holder, then the question is, how should it be regulated? If the financial product function is an incidental component and its primary purpose is not to operate as a financial product, should it be excluded from the scope of regulation as a financial product along similar lines to Section 763 E of the Corporations Act? In other words, how do we deal with the regulation of crypto assets that have multiple potential functions? And I'd be interested to hear views from other panelists on this issue. Another question, one that we've raised at the ALRC in the background paper, is whether it may still be necessary to define crypto assets for certain purposes. For example, if there are any crypto-specific obligations that are imposed on crypto asset services providers, but not on other financial services providers. So let me say something now about Decentralised Autonomous Organisations, or DAOs. First, what are they? Well, let's start with a simple definition. As we noted in the background paper, and putting it in very basic terms, DAOs are described as decentralised because they remove the need for centralised management. They are described as autonomous because they operate in an automated manner and in accordance with the rules encoded in blockchain-based smart contracts. DAOs are described as organisations because they operate as business networks. In reality, DAOs can be used for a range of other purposes, including social or non-profit purposes, and it'll be interesting to hear Miles's views on that a bit later on. In their purest form, DAOs possess three attributes. First, they are permissionless. In other words, they rely on public networks rather than private networks. Secondly, they are decentralized in terms of their governance. In other words, there's no centralized control mechanism, and DAOs usually rely on either on voting by governance, the holders of governance tokens, or alternatively, they are governed by an algorithm. The decentralized nature of DAOs is the position in theory, at least, as anecdotal evidence suggests that very few DAOs are completely decentralized. And once again, I'd be interested to hear the views of other panelists on that. Thirdly, to date, in most jurisdictions at least, DAOs have been unregistered. In other words, they haven't been established in a registrable form. All of this creates regulatory challenges as DAOs, at least in their purest form, don't fit easily within the existing regulatory framework, largely for the reason that there are no intermediaries to constitute the mind and will of the DAO or represented in off-chain dealings, and the arrangements are not expressly governed by law and legal contracts. This gives rise to implications in terms of protecting consumers and third parties who deal with DAOs, and also how DAOs might be sued and held responsible for wrongful acts. To date, many thinkers and writers have treated DAOs as analogous to other business forms, such as partnerships and unincorporated associations, and have suggested that they should be regulated accordingly. However, there are certain anomalies and inconsistencies with that approach, I would suggest. Another issue, as I mentioned just before, is that one challenge with crypto assets in the context of DAOs is that tokens may perform hybrid functions. That is, they may serve both as securities and as a medium of exchange. So briefly, what about the second question? Who's responsible if things go wrong with a DAO? As I mentioned, in their purest form, DAOs are unregistered. This creates challenges for their regulation, as the lack of registration or registered agents means that they operate on a borderless or supranational basis, and there's no nexus with any specific jurisdiction. Given the practical difficulties of regulating DAOs, one question I would suggest is whether we should be more concerned about regulating autonomous organisations, namely autonomous organisations that are not decentralised. As the ALRC noted in its background paper, one regulatory choice is to regulate wrapped or hybrid arrangements under which a DAO operates through a company or other corporate form, and to leave the regulation of DAOs in their purest form alone. And I'd be interested to hear Joni's views in that regard. So I'll leave my opening comments there and hand the mic now over to Lawrence White, who'll speak, as Rosemary mentioned, about the regulation of crypto assets in a global context. Thanks, Lawrence.
Thanks very much, Andrew. Okay, so I'm just going to talk about the current state of regulation of crypto assets in Australia, and I'm focusing more on financial services and financial regulation than on tax and perhaps some other issues. But and then I'll talk a bit about the global context in which is obviously undergoing a huge amount of change and ferment at the moment. And then I'll sort of come back to the proposals from Treasury and regulators, but I think Andrew's already touched on the token mapping exercise very well. So I may give that a bit less attention than I would have otherwise. But in Australia, we have a number of regulators that are already interested in crypto assets, and in certain circumstances, intermediaries, issuers, those promoting those dealing, arranging deals, etc., need to be regulated. So AUSTRAC, of course, regulates DCEs, digital currency exchanges, today, and has done so for some time. This is a registration system, not a licensing system as such. ASIC runs 3 licensing systems that are potentially relevant to crypto assets, depending on what those crypto assets encode or what function they perform. So there's the key one probably is the Australian Financial Services License Regime, or AFSL. The second, the AML regime, the Australian Market License, not to be confused with anti-money laundering. The credit license regime under the National Consumer Credit Protection Act. And then APRA, of course, authorises our banks and some crypto assets facilities and providers might need authorisation either as purchase payment facilities providers or as conducting banking business otherwise. And lastly, well, I've mentioned their purchase payment facilities. So there are a couple of large facilities that are dual regulated by RBA and APRA. In terms of the Corporations Act, Chapter 7, which is kind of my bread and butter in terms of advice to crypto assets issuers or exchanges, I've highlighted there. So the concept of financial product is broken down into sort of 2 main pillars and then 1 exclusionary pillar. And the main pillar is what's already been mentioned, the functional definition. In other words, a facility through which or through the acquisition of which a person does certain things, makes a financial investment, manages financial risk, makes non-cash payments. So that's the functional definition arm. And then we have a bunch of specifically inclusions in the idea of a financial product, and they're very important too. So we have, in particular, the key ones are whether something's a security, whether it's an interest in a registered managed investment scheme or certain unregistered schemes, or whether it's a derivative. So I've highlighted in light blue there that the sort of inclusions and definitions that I tend to have to work through in detail for clients in this space. But then there's also a range of filters that take you out of the concept of financial product, and they tend to be quite specific exclusions. So for instance, credit facilities other than margin lending are excluded under 765A or capital A. Certain non-cash payment facilities are excluded under one of the regulations. And then ASIC also has made a bunch of declarations that take certain products outside the scope of financial products, including loyalty schemes, road toll facilities, and so on. I've put an asterisk down there because the DDO that does the design and distribution obligations, a fairly new regime that's come in the last couple of years. They do apply to credit facilities, even though they're not financial products. And this is a key point that's sometimes missed by some advisors, in my experience. There's a Menga sponge on this page, this object here. And the purpose of putting that there is, I sort of think of it as quite a good analogy for the way the Corporations Act kind of works. So it does set out very broad boundaries, but then the exclusions are quite important. And then there are sub-exclusions from the exclusions, and there are sub-exclusions. And I won't labour this, but the table on the right hand of the slide, prepared by the ALRC and published in November, is a very helpful cascading diagram of all the different exclusions that might apply when considering whether you're providing financial advice. So if it looks likely that the crypto token in question might be a financial product, then the next question is, well, are you actually providing any regulated service for that product? Because if you're not, then normally you wouldn't require any license. If you do, then normally you do require an AFSL, unless you're exempted. So there are many layers of exemptions with many different sources, and I think that's probably enough to say about that. But I think I'm giving a fairly familiar picture of complexity around this existing regime. ASIC has given some guidance over the years. I say some because many people would say that it's been more in the nature of signposting to existing bits of the law rather than trying to explain how those bits of the law actually apply to crypto assets. The first thing that I tend to go back to is what they told the Senate in 2014, which is ASIC, and this was in the days where Bitcoin was, and it was really the only significant crypto asset. And I can't remember if Ether had just launched or not, but ASIC considers that it's unlikely that a digital currency is a facility through which a person makes non-cash payments. It follows that digital currencies are themselves not financial products. Well, actually, it doesn't follow because there's so many other categories that a crypto token might fall into. But for many years, this was about the only guidance in the space, and it was, I think, quite helpful, at least to the crypto token industry, to take a degree of comfort that if they kept to vanilla cryptocurrencies, as opposed, say, to things that encoded cash flows or looked like securities or derivatives, then that they wouldn't need AFSL. And indeed, that has been the way the industry has developed in Australia. Info 2019 219 is about evaluating DLT, not particularly important. Info 225 is the key one, and I'll get onto that. Info 230 is fairly niche, but it's about what exchanges need to look for in crypto assets that are going to underlie exchange-traded products like the Bitcoin and Ether products that we've seen admitted recently. ASIC made a more another submission to the Senate inquiry in 2021, making it clear that Info 225, that ASIC makes it clear in Info 225 that whether a crypto asset is within or outside the financial regulatory framework depends on particular characteristics of the offering. No surprise there. This can cause uncertainty, yes. It's a policy matter, though, for the Australian government, whether or not there should be clarity on this issue. And some might say, well, ASIC could have actually written out a lot more guidance like the FCA has done in terms of perimeter guidance. Others would say, well, the crypto asset market's changing so quickly that kind of guidance would quickly go out of date. And anyway, it's not ASIC's job to give crypto advisors legal advice. And so ASIC, I think, has deliberately chosen to keep its guidance quite high level. There's obviously been quite a few speeches as well there. Joe Longo in August last year said, "It's not my job to be a crypto cheerleader. My job is to protect consumers and administer the law." And I think under the previous government, there was a little bit more emphasis on innovation and the benefits of the crypto space. Under this government, a little bit more emphasis on protecting consumers. But still, an acknowledgement that there needs to be work done on the regulatory regime. Info 225, look, I won't labour this either, but I suppose the key point here is around this one, crypto asset investment products. So if you're operating an investment product that offers investors exposure to crypto assets, a range of Australian laws may apply, yes. And the discussion is limited to inclusion as a financial product due to the product being a security, a derivative, an interest in an MIS, or a non-cash payment facility. So no discussion of the functional definitions, which is a bit odd because now Treasury's come out with a paper which is almost all about the functional definitions and really sort of puts the others to the side. So that's 225, that's 2021. I think it has been updated once or twice. And there is also some quite important so-called good practices set out for crypto assets custody that are really quite helpful in the sort of guidance that one might have expected ASIC to provide around some other topics, but that is an important aspect of 225. Meanwhile, APRA, so Basel Committee, after a long consultation process over 2 years, has finalised its crypto assets recommendations for prudential, so for capital treatment of bank exposures to crypto assets. They've kept the regime very conservative, I guess, contrary to submissions from both the perhaps the crypto sector and also the traditional financial sector that sort of wanted to have a bit more freedom to invest here. The financial regulators clearly worried about risk emanating from the crypto sector and infecting the traditional financial sector, weakening banks and so on. So they have put quite severe sort of capital penalties, in particular around unbacked crypto assets, things that are not stable coins or that don't reference real world assets and that are essentially speculative tokens. They did put out a letter in April last year that was pretty motherhood and apple pie, sort of telling banks that they needed to do robust risk controls, appropriate due diligence, but wasn't telling banks at least that they shouldn't invest altogether in crypto assets, which is what some central banks have told their banks. And there's a timeline out to 2025 by which APRA expects the new crypto asset requirements based on the Basel standard I just mentioned to be in force. Meanwhile, ASIC, after a long period of more or less benign neglect of the crypto space, or malign neglect, depending on your perspective, has sort of got quite tough actually in the last few months, and has not only tough, but I think also is obviously interested to explore the legal boundaries. And so, for instance, with Block Earner, which is a fixed yield earning product, they've alleged that the company Web3 Ventures that was running this scheme was operating a managed investment scheme, unlicensed, also an investment facility under the first pillar that I mentioned earlier, and offering derivatives. On the other hand, they're alleging that Finder Wallet was issuing debentures. So they've really taken a leaf out of the SEC's book, which has been accused of regulation through enforcement, but at least we're going to get some clarity through case law around these quite important categories. And at the end of the day, the Treasury and government don't show any signs of walking away from the functional approach to regulation. So we do need this clarity, I think. Meanwhile, global standard setters have been very busy. I won't rattle through them all. The FSB that I did work at for 3 years, ending in 2019, has just closed its consultation on both crypto assets and stablecoins, and that was a very important consultation. And their recommendations are expected in mid-2023, and they'll be really quite epical. I think a lot of regulators are kind of waiting for them to land before they kind of roll out their final standards on crypto. As a consultant, I helped the Institute of International Finance with its digital assets work, and I did help to pen their submission on those papers to the FSB. So I'm watching that carefully. The Basel Committee I mentioned, CPMI OSCO is really worth watching this year because they have two work streams, one led by the FCA, the UK regulator, I should say, on crypto assets and crypto and digital assets, and one led by the SEC on DeFi. And at least the first one will end with recommendations to securities regulators in 2023. I suspect the SEC-led work stream will be probably less ambitious in terms of recommendations, but let's see. And we may see some consultation papers come or interim reports come from IOSCO this year. OECD doing amazing work on DeFi in particular, and FAT have updated its guidance in 2021 around virtual asset service providers. Look, I won't go into detail here, but suffice it to say, MiCA is not the only game in town. The UK has just launched a really important consultation, HMT, which closes end April. They basically have in phase one stablecoins, pound-denominated stablecoins, and in phase two other crypto assets, and phase two will probably break out into multiple phases. They've also clamped down on financial promotions. The US position is very complex. There's been an executive order in March last year, any number of reports about what might happen, what could be done, a lot of browbeating. The SEC obviously just has given up hope of having significant legislative change anytime soon, and is out there really strongly enforcing its mandates and its rules, or its view of the rules. Singapore and Hong Kong, Singapore's already done quite a lot in 2019 around Payment Services Act and digital payment tokens. They're looking again at crypto. They clamped down on public advertising, and they've closed a consultation on the regime. Hong Kong is sounding a bit more liberal today than it might have been maybe a year ago, and maybe is trying to position itself as a bit of a crypto hub, which it probably already is. Dubai has set up a separate authority, the VARA, for non-securities virtual assets. They've just published some regulations in the last day or two. So it's going all guns blazing. Japan, South Korea, stablecoins and exchanges. China banned almost all forms of crypto mining and trading in 2021. Chainalysis says the market's still very active, suggesting the ban has either been ineffective or loosely enforced. On the other hand, mining volumes have moved very significantly to the US, Germany, and a bunch of other countries actually. Look, I'll wrap up pretty quickly, but common themes. The main theme is client asset segregation and custody. You know, we've seen at FTX, Celsius Networks, Voyager Digital, others, just this really gross failure to separate client assets from own assets, rehypothecate client assets, have some huge liquidity mismatches, huge denomination mismatches, fail to account, fail to mark to market. So there's common themes there on that slide, and the slides will be available after the session. On Australian proposals, this is a bit of a complicated picture, but you know, there are some elements of continuity from the Morrison government to this government, and some discontinuities. Continuity elements. The CFR review of stablecoins has been ongoing for ages, hasn't really issued anything, any CPs. That must be feeding into this consultation on the payments licensing network we expect in 2023. The RBA review of retail payments came out in October 2021. Obviously, the Farrell payment system review, the Bragg report, the PJC inquiry into mobile, it's all sort of part of the background. The token mapping exercise is part of this, but it's not the whole story. There's a whole huge, so much broader review of payments that's happening in the background. Obviously, the crypto, I mean, the other thing to note is the crypto token mapping consultation is only 28 days. Now, by global standards, that is like the blink of an eye. And you'd sort of wonder, there's a tendency, I think, for those sort of super short consults to favour insiders or people who have really good working connections with Treasury or the regulators, rather than getting a broad range of views from perhaps internationally or academia or whatever. Anyway, that's closing on the 3rd of March. And so I think with that, Andrew's already covered this paper. That is, I think the key thing here is the functional approach really does go back to FSR basics, financial system reform basics, CLERP 6. So it's I think a welcome back to basics and back to legal basics paper from the Treasury from my perspective. So with that, I'll stop sharing my slides and I'll hand over to Joni Pirovic.
Thanks, Lawrence, and thank you for Melbourne Uni and the Australian Law Reform Commission for convening this event. Thank you all for joining us today too. So I'm going to start, I'm going to pull back and use a little bit of an analogy to help describe where we are at a point in time in DAOs, and try to make them a little bit more visible and understandable for you, that for all of you that are sitting back and going, but what are actually these things? So the innovation back hundreds of years ago, that was the paint tube. Very, very simple innovation, but it allowed the French artists to paint outside. And this was an evolution, an innovation, because finally they could see the sunset, they could capture the light, they immemorialized the mood of people, pedestrians walking across the road at sunset. But they had to paint very quickly, because in order to capture that essence and the light, they had to do their work very, very fast. And so the name given to this group of artists, as you might all know, is the Impressionists. And I was inspired by this analogy by attending the Monet exhibition at the Loom Gallery, which I highly recommend. But this is a really good way of sort of looking at DAOs. And we've really only been an industry just over or just under 10 years old. So if you think about the launch of the Bitcoin network as the first or the earliest example of a DAO, then yes, we are only just over 10 years old, but the DAOs as we know them today, where they govern these applications built on top of blockchains, that really only eventuated in 2021 in what we call DeFi Summer, when the comp token was launched as a governance token by the team that looked after the Compound protocol. Now that's a lending and borrowing type function, you might call. But to use this analogy, a lot of the governance interactions or activities that people do in relation to a DAO, it's micro interactions. So on Discord, on Telegram, on Twitter, other governance fora, you'll see a lot of members, in a lot of cases, hundreds of thousands of members of these social media forums contributing to providing feedback on what the protocol functions are now, how they could be improved, how governance could be improved, looking around and monitoring for security threats and alerting the community to them. So there are many, many different inputs. And if you were actually to use some piece of software to get a data visualization of sorts, I suspect that what would be produced would be very similar to what the Impressionists were painting as that very, very fast capturing of the essence of a particular time. And what DAOs at their foundation do represent is the essence of wanting more or wanting something different from our existing entity structures. So the common question is, why can't you contain a DAO into a company limited by guarantee or a proprietary limited, normal private company? And it is a hard question to ask, because DAOs exist on a spectrum, and a lot of the smaller ones that do start with very proximate, and small number of people, not necessarily thousands or hundreds of thousands across multiple territories, it does make sense that those sorts of organizations are probably best contained or incubated in one of the traditional company structures that we're very familiar with. And in fact, a lot of the early DAOs launched the software protocols from a limited liability entity, and the governance token was launched from a separate entity. Usually this is called a legal wrapper, and you find most of them in the jurisdictions like Cayman Islands, BVI, but the Swiss Foundation has also been a commonly used structure. So with that background, I just wanted to give you the impression that DAOs as a thing or as an industry is still very young, and they are still maturing. But what the role of policy might be is to protect that innovation in the most responsible way. And one of the things that we can do is to figure out, come to consensus on what the basic standards for legal recognition of a DAO, for it to have distinct legal personality, as well as on what conditions it should be granted, or its members should be granted, limited liability. Now, this is not an easy question to answer. There are a lot of academics around the world trying to solve, but one group called Koala, which stands for the Coalition of Automated Legal Applications, they penned the DAO model law in 2021. And this is a proposed set of standards for governments or legislatures to adopt, and it gives a basis. It gives the very, very base standards that do put a DAO on some sense of equivalence to companies that we register or cooperatives that we register, and we grant that limited liability status. So I encourage you to look at the DAO model law, read it, engage with it. I've recently been engaged by that organisation to help them as they negotiate and support various bodies as they go through the legislation process. So some of those are, the public ones I can mention are Utah and New Hampshire in the US, each of which have proceeded to draft bill stage. But the New Hampshire bill may take a different direction to the Utah bill, in that New Hampshire is very much concerned or comes from similar perspectives as we are in Australia, to fully understand how, if they do give legal recognition to a DAO, how does it interoperate with the existing division of companies or securities registers, and how does a DAO pay tax? So these are all of the administrative, sometimes boring but crucial questions that we are literally discussing now and trying to resolve and come to consensus. So the Koala DAO model law prescribes some foundational or some formation requirements. One of those is that it needs to be deployed to a permissionless blockchain. So picking up some of the Treasury token mapping concepts of permissionless and public network, the fact that the DAO is deployed to a public network is one of the formation requirements, and indicates that the DAO has the capability of being technically decentralized, even if it may not be operationally decentralized. And this is a key distinction, because at the outset of a project, there are often a few key people or a core team that is heavily involved and a quite centralized operation before there is trust in the protocol. Another of the formation requirements is that the protocol is quality assurance and security audited before it is deployed. Again, so there's almost a replacement of directors' duties or fiduciary duties as we know them, and moving towards a different type of duty of faithful implementation of process, so that we can trust the security, trust the protocol and the autonomous nature of the protocol as we are going to interact with it at scale and almost on a microsecond basis when you look at some of the big liquidity protocols. So have a look at all of the formation requirements. Each of them warrants their own 1 hour or probably 1 day discussion, but at least we've done the initial work in putting together some initial formation requirements. So Koala DAO model law is certainly an approach that's being used by some jurisdictions. Others are just seeking to look at existing principles of unregistered entities, like an unincorporated association of persons, which acts through its offices, or a general law partnership, which may be deemed based on the substance and the economic activities going on by each of the alleged partners. The partnership model has its pros and cons, as does the unincorporated association one. But if we're going to continue to rely on those entity structures, at least from an Australian legal perspective, there's some significant fallbacks to them. One of them is there's a particular provision in the Corporations Act, Section 115, which treats as illegal any unincorporated association of persons that is formed with a for-profit purpose and has more than 20 persons. So this would actually capture most DAOs if you conflate a for-profit purpose with the governance token's ability to go up and down in value. And so if you do take that one step further and suggest that all of these associations of persons are actually illegal associations of persons, the tokens that come from that entity, it's a very difficult thing to reconcile that we've had the AML-CTF Act, the GST Act, give legitimacy to tokens when they're used as digital currency, but yet the underlying organization could be treated as illegal. And so this is one of the fundamental things that we need to solve, because if we don't retrospectively grant legal recognition and some sort of transitional period or safe harbor, all of this talk about regulating crypto assets or tokens or token activities, the pipeline of tokens dies if you don't support the form of organization that is responsible for bringing these tokens to market. So yes, there are stable coins that are probably going to be issued by central actors, centralised actors like banks. There'll be other tokenised real-world assets that will be issued by those central authorities. So all of those intermediated token systems, to pick up the language again of the Treasury token mapping paper. But the fundamental innovation of what we're seeing in efficiency and effectiveness and transparency of business processes, as well as processes that could be automated within government administrations, that stuff is happening in DAOs. So I'm going to try, I'm going to hit a surprise on you all. I'm going to try and share screen just to illustrate some of the complexity involved in trying to not just launch a DAO, but undertake activities under a structure that's potentially illegal, but if not illegal, that exposes its members to unlimited or joint and several liability. So coming from the LawFi DAO perspective, in LawFi DAO, we've got a number of purposes, one of which is to educate the public about DAOs. And one of the proposed experiments is to bring to the world a pay-to-rely protocol. And it could be used by lawyers, medical, accountants, you name it, any profession could really leverage from this technology. But we're hampered by a lack of understanding of what a DAO is legally, as well as for tax purposes, but also how each of the functions of the protocol may be regulated and require registrations and licensing, not just in Australia, but around the world. And this is what suggests a truly transnational or an international model approach, why that is required. So as the name suggests, you pay to rely. And the model proposes that there is a provider. It might be me and my law firm. I write a piece of tax advice and I launch it or I deploy it on the blockchain as an NFT, a non-fungible token which links a document tax advice to it. A customer in the public is able to view it and they say, yes, I do want to know how my Ether is treated when the Ethereum network transfers from proof of work to proof of stake. And so they pay to rely on that particular tax advice. And at the same time as there's that payment, there's the automatic production of the engagement letter and the cost agreement and autofilling of particular details. But this is just the basic protocol. If we want to actually enhance the reliability and the robustness and the confidence in that piece of advice, we can introduce peer reviewers. And the technology is already capable of us splitting some of that revenue and allocating it to a peer reviewer pool and then out to the different peer reviewers. Insurance is a big question. Anything to do with token activities typically can't get insured, and if it does, it's at a very high premium. So instead of minimum capital requirements, which are no longer a feature of Australian companies or most entities around the world now, having a compensation scheme of last resort that the DAO itself provisions for could make up some sort of insurance scheme. And again, it might split some of the revenue to fund potential claims against the DAO. Finally, there could be another pot in which revenue is split that goes to one or both of grant making to similar DAOs and charities, or you might use it to repay financiers. So it might be a return on a debt instrument, or it could be something like a dividend. Now, each one of those options in itself comes with great legal complexity as well as tax complexity in Australia, let alone if you're looking at multiple jurisdictions. And if we want to do all of them as a startup and as a beginning DAO, it's almost impossible. So we could have achieved this last year, but there's no safe harbor, there's no regulatory clarity. We'd be forced into building this protocol within a company, a limited liability company, and launching it onto the world with the IP held in a foundation somewhere. And being forced into that kind of structure leaves us with other questions that if I'm dealing with an autonomous protocol, is it itself a legal person and a trustee in the sense of me putting up tokens as collateral? Currently, the Australian Tax Office in their preliminary views are saying, because there's no human, there's no actual counterparty, what you might actually be dealing with is the cancellation of your rights in relation to those tokens when you engage with non-human or personless protocols. So there's fundamental questions that will all be solved, well, a number of them will be solved if we just tackle the hard question of DAO legal personhood to begin with. So I'll stop sharing that, and that's to try and give you some of the really difficult insights or difficulties that we're going through in LawFi DAO and how we feel hampered in not being able to move forward with the innovation. There is a lot more complexity, and if you want to follow the LawFi DAO journey, all of our community calls and workshops have been recorded and are available on YouTube. So it's a great archive for you to follow an Australian perspective, a legal and tax perspective, to truly understand some of the difficulties we've been going through, even just to get comfortable as to whether we're operating in a not-for-profit purpose or if there are for-profit things that could be construed based on our activities. So we're a very conservative group, mostly of lawyers, and we haven't been able to move forward on the protocol due to those uncertainties. So there is one final screen that I'll share with you while I answer some of the questions that Andrew raised. And forgive me, I won't go to that because I'm at time, but if there's further opportunity in the Q&A, then happy to go through a final demo of the DAO registry that we're building to make DAOs more visible also. Thank you, and over to you, Miles.
Thank you, Joni, and I've been privileged to be part of the journey with Joni of LawFi DAO, and I'd encourage anybody who's got the time and interest to join that. I'd just like to acknowledge the traditional owners of the land. I first want to have a bit of a caution about beware knee-jerking politicians and regulators. This is an incredibly exciting area. As people have said, it's incredibly fast-moving, and if I was a young lawyer starting out again, you know, this would be incredibly attractive to me. Unfortunately, I missed out on years of playing games on the internet, which seems to be a big advantage to understanding DAOs and Web 3.0. But with people like Joni, even dinosaurs like me come to some understanding about it. But dinosaurs have a history, and the history I want to just point to you is that in England, the company that we now regard as an engine house of commerce and productivity and wealth was stultified for over a century. The South Sea Company was a British joint stock company that was established in 1711, and it was a public-private partnership to consolidate and reduce the cost of the UK national debt. To generate income, it was granted a monopoly to supply African slaves to the islands of the South Seas and South America. And this was funded in a stock exchange, and it was in fact the first stock market collapse, particularly as the Spanish and Portuguese controlled South America, so sale of slaves was a little difficult. The Parliament in England responded by forbidding the formation of joint stock companies unless approved by them and through what we call joint charter. Nearly a century later, this was repealed, and it wasn't until 1844. Oh, sorry, this was repealed in 1825. Lawyers got busy with all sorts of interesting legal drafting techniques and trusts to try and protect shareholders and unit holders from liability. There were varied judgments in the courts, but it eventually left the Parliament to give in 1855 limited liability. And this was brought on by a flight of capital to other jurisdictions, and with the flight of capital to USA and France, it also meant that England was losing out on tax revenue. Now, perhaps there's a hint about what a major driver may be for DAOs and their regulation and facilitation. It may all come back to loss of tax revenue or taxing. I like to, when I was teaching company law, tell my students, company law really is all about infrastructure and not necessarily about regulation, stupid. You've got, I think, as policy makers, they've got to chew gum and walk at the same time. You've got to facilitate the entity to occur, but you've got to regulate it as well. Doing one without the other is not optimal. Some bouquets. Well, I'm throwing brickbats to our policymakers, and that's Treasury seems to have adopted a technology neutral setting, which I think is excellent. And then the Australian Charities and Not-for-Profit Commission has issued a guidance which is relatively benign, and I think strikes the right climate for charities and these new crypto assets, distributed ledger technologies, and DAOs. Just a quick bit of theory about what makes nonprofits competitive, and you'll see where I'm going in a moment, so just hang in there. Professor Henry Hansman, who's my hero from the US, pointed out a thing called the non-distribution constraint, which is in every nonprofit's constitution. Henry was a student of a transaction to the professor who developed transaction cost economics, which was about the friction in the economy, friction in the market. And so transactions and enterprise gravitated to where there was less frictions. And Henry said, with respect to nonprofits, the non-distribution constraint, that is, that you could only use the assets of the association or the entity for its purpose and not for other purposes such as excessive remuneration or private profit or distributive dividends, was a competitive edge to other market participants because it reduced transaction costs. Now, the theory goes into what areas of the market nonprofits have this competitive transaction cost advantage. It's not in every part, but in certain parts it does. Education, healthcare, where it's often difficult for consumers to have voice and exercise rights. So what Professor Hansman was saying was that nonprofits can save on transaction costs. If you wanted to get a spade to, let's say, Turkey or Syria at the moment, you could give some money to a for-profit you'd have a contract with them to get the spade to delivered to somebody in Syria or Turkey, but then you'd want to monitor it as well. And forming contracts and monitoring are costly exercises. Whereas with a non-profit, you can save on those transaction costs. You give money as a gift. It organises delivery, and you would trust the non-profit to deliver it because you can't spend the money on anything else other than delivering constitutionally delivering the spade to the right people. Now, I know that there are lots of leakages in that, people with management with their snouts in the trough, or other empire building, or pure fraud, but you'll see the basic argument there. And that's where blockchain and distributed ledger technology comes into its own, because I think at the heart of this is it's reducing transaction costs in the marketplace for all, for-profit and non-profit. So it often cuts out the middle person. It's peer-to-peer. Governments and regulators are bypassed and the costs with that, although they do miss out on the facilitation, which we're seeing now with lack of limited liability for bespoke DAO wraps. And the other thing is provenance of transactions on the ledger can be assured. And the thing that's missing, as far as I'm concerned, is digital identity, knowing who you're actually dealing with. But I think that will come. So all of these save on transaction costs, which is, in financing and whatever, they're all going it to save on the costs. For DAOs, that's the organisations, which are formed here. Clearly, blockchain will have implications in saving transaction costs in financial transactions that the DAO may have. Voting, because it often lacks a central management, so voting can be done by the blockchain, and code as a contract. So DAOs offer us a way of saving, of cutting transaction costs, and in a market that's pretty much important. And it applies both to for-profits and non-profits. Next point I want to make is that non-profits have successfully managed unlimited liability for centuries. They're often unincorporated associations. I just point these as for clues for people who want to look for some solutions or some places to get ideas. So faith-based organisations, churches, act as consensual compacts in law rather than members having a web of contracts as you would have in a publicly listed company. And that's a different way of thinking of relationships. There are various management strategies of unincorporated status and their liabilities that have worked pretty well. Some churches are thousands of years old, amassed incredible wealth, and it's all while there's not a corporation in sight. So there are ways of doing it. May come back to be too good in terms of the Alice offence and sexual abuse and trying to hold them to account. But there are strategies and various strategies and strategies other than insurance, which they have successfully used over centuries. And then there are some exotic non-profit legal forms, which I think may hold some gems for DAOs. Mutuals or cooperatives. I've noticed in many DAOs, particularly on the non-profit side of things, that they really have a mutuality feel about them, and cooperatives. Now, I know cooperatives are not flavour of the month as a legal entity. When I was started 20 years ago, there are a couple of thousand cooperatives in existence in Queensland, and now I think there's less than 100 operating cooperatives. But for various reasons, which I can go into later, I think that they hold some absolute gems for DAOs. Companies limited by guarantee and shares. Now, you've heard Joni talk about a company limited by guarantee. There used to be a company limited by guarantee and shares. What this allowed, the shareholders can contribute capital and get a return on it, and the members would be members in a non-profit. So it was a division between for-profit and non-profit, a unique form. And the other one is an entity from the UK, England, called the Community Investment Companies. And these were designed some years ago where there's an asset lock on return for capitalists who provide capital, so that they can get a return, but it's capped, and they involved in basically non-profit activities. So there's some ideas, and we can talk about that more in future seminars. I want to talk about giving circles as an example of how DAOs can be perfectly used and are perfectly suited for philanthropy. So a giving circle is where people get together to pool their donations and collaborate around where they're going to send the money or distribute the money. This has been taking off for some years in the US, and they're growing rapidly. And it's called the democratization of philanthropy, where people from the same profession or firm or neighborhood all get together, throw in $100 or $1,000 each, and then decide what they're going to contribute the pooled funds towards. An example recently was a DAO got together to buy one of the rare copies of the American Constitution because they wanted to go on public display, not into a private hands to sit in somebody's living room or vault. And they raised over $47 million to bid at the auction. They were unsuccessful, but it was able to be, the funds were able to be return to all their members because it didn't come off. So that's another example. My favourite, because I love growing plants and particularly orchids, is Kimball Musk, and yes, he's a relative of, and his DAO, which is claims to be the first non-profit philanthropic DAO in the US, called Big Green. Big Green, you can see the principles there, is a charity registered under 501c3 in the US with tax exemption and deductibility status. They've been teaching people how to grow food. They've supported schools, families, and communities. They not only collect donations, but they give out grants to schools and community organisations to foster education about community gardens and growing and creating support, and that's all very interesting. Note that these organisations often have these principles here, and Law DeFi DAO, and Joni's got some excellent principles. And this leads me to cooperatives, because cooperatives often have these overarching principles as well. And you can see there how you can donate and get a tax deduction. They fund the governance, both the donors and donees both get tokens to vote, and so off you go. I've run across a couple of homegrown Australian DAOs that I'd like to share with you. The Digital Playhouse, have a look at them. They're doing some fantastic work, and they're so enthusiastic and great people to talk to, and the work they're doing is from what I can see is really great. So check them out. They're a DAO. So warning here, I think I'm the corporations law would call a related party. I have a relation who's involved in this one, but nevertheless, this is a charity with the ACNC registered, and it's doing all sorts of things about fungible tokens. They started off running cryptocurrency lotteries and raffles for charities on the web, and so they're enthusiastic young coders with an altruistic vision, and they're doing great stuff. And one that's really captured my attention, they've teamed up to the Foundation for National Parks and Wildlife to do NFTs with respect to trees. So you get a mint for a tree, and they plant a real tree. And in fact, there is a video on YouTube where they explain how that the foundation wants to buy a whole big tract of land, and what the team have done is, or want to do, is to render the tract of land into a metaverse, and you can buy a small part of it and name the hill or name the tree or whatever, and the funds go towards actually purchasing the park for real. And another Brisbane group who are incredibly enthusiastic and doing great work and very industrious. You can see there that they're all over all sorts of things with wonderful ideas about philanthropy and giving, and looking at transaction costs that can be stripped out of the process, and taking advantage of that to maximise the benefits for philanthropy and for non-profit enterprise. So I know time's running out, but I really encourage you to go and have a look at Little Phil and talk to them. They are very supportive. I think we're about here at the moment. Which end will come out at, I'm not quite so sure, but I hope it's the right end. But I really think our policymakers in Australia and perhaps around the world really have to be technology neutral. There has to be appropriate facilitation as well as protective regulation to get it right. And I think the benefits that can be brought to society and globally generally by reducing the transaction frictions will benefit us all. And it's a new way of looking at the world. It's a new way of relating, and it's exciting to explore the possibilities for good of this. So thank you very much, Rosemary and Andrew, and I'll hand back to you, Rosemary, for questions.
Okay, thank you very much for those very thought-provoking whirlwind presentations. There's so much in these topics, and we've certainly covered a lot of ground. We don't have much time for questions, and I've got a number of questions here. I won't be able to get to them, but as I mentioned, we are planning to hold some more webinars where we can explore some of these issues. I've got one here that I might pose to both Lawrence and Joni. So the question points to recent academic literature suggesting that DeFi may not be as decentralized as it purports to be, and that many DeFi functions are often centralized. So the first part of the question, Lawrence, how does this impact the future of DeFi applications, or will we see more of a transition towards centralized CeFi applications? And perhaps, Joni, perhaps I might ask you, should the founders of DAOs be excused from responsibility if they outsource functions to a smart contract protocol? I think we could have another entire webinar on that, but perhaps if you wouldn't mind just answering those briefly. Thank you.
Thanks very much. So I guess it's worth noting that most of the collapses in 2022 were either of relatively centralized crypto asset businesses, or if they were decentralized, they were probably decentralized more in name than in practice. So there is this idea of the DeFi illusion that the regulators, IOSCO, has put forward, and certainly regulators are very skeptical about claims that the bigger projects are truly decentralized. Having said that, most of the big DeFi projects, truly decentralized ones, have been relatively stable. So, for instance, the DAI hasn't suffered the same losses of confidence that, say, Terra Luna did. Also, that are starting to creep into Binance, the BUSD, and other tokens like that. So, decentralized finance per se need not be unstable, but the OECD and others have pointed out lots of limitations. One of them that the IF pointed out in its report on DeFi was the pseudonymous nature of DeFi tends to mean that lending is over collateralized, which tends to favor people who already have a lot of assets rather than driving financial inclusion, and others have pointed this out as well. There may be technological fixes there. And look, I think it's still early days. As AI comes more and more into the picture, general AI through things, we've seen chatbots making leaps and bounds with ChatGPT. It's not beyond the bounds that general AI could play the role of human intervention that, say, the FSB foresees in its stablecoin standards. So the FSB language on human intervention is pretty technologically non-neutral, right? It's saying that a human is always going to be better than a robot at crisis management. And, will that always be true? Who knows? So I think we need to look carefully at what IOSCO is going to do this year, and these debates will just keep rolling on as AI becomes more and more powerful, I think.
Yeah, great questions. The tulip trading case that's happening over in the UK at the moment is very helpful as to fiduciary duties of developers, and particularly developers of open source technology in which any person around the world can download, access and use. So in an interlocutory proceeding, the judge has just, to step back a bit, Tulip Trading is a company incorporated in the jurisdiction of England and Wales, and it brought an action against 16 or so of the Bitcoin network developers, the core developers, and it brought it against them as individuals, not as a partnership, not as an unincorporated association of persons, separate individuals. And they are only a subset of the thousands of people, like I said, that are looking at the code, contributing to forums, really contributing to the sentiment of whether a particular upgrade to the Bitcoin protocol will be supported or not. And so in this interlocutory proceeding, the judge has said it can't decide on the particular matter because the remedy wouldn't be effective. Even by saying that those 16 may have had fiduciary duties or something like fiduciary duties, to order a remedy that they upgrade the protocol, and what Tulip Trading was asking for is that the protocol be patched so that the $4 billion worth of Bitcoin tokens that he'd lost his access key to, or I think it was hacked and stolen, is the suggestion, that this software patch could reinstate his tokens so that he could realize his $4 billion worth of value. And that was the remedy that the judge was not willing to instill. And so this open question of what are the ongoing obligations of developers, and if you can't bring all of them into a court matter, and there's no effective remedy that can be sought against just a few of them, then we truly are dealing with autonomous software. And so that's why you need to go back a step and look at the faithful implementation of process, or the faithful building of that protocol, including security and quality assurance, so before it's released to the public. And so some are resistant or say that the technology should be free from censorship, but basic things or protections around our property rights or our ability to recover property, such as tokens, or our ability to access them, this is something that I probably think will be dealt with in those formation-like requirements, sort of a recovery process. But we're yet to see how the case law evolves. I think that there will be appeals in the matter. I'd love to give a longer response, but I know that time is limited.
I can't help jumping in and just referring to the CFTC versus UkiDAO matter, where CFTC identified the defendant as an unincorporated association of the governance token holders of the UkiDAO, but only those who voted their tokens. And so that's an interesting way to cut the cake, and it does beg the question as to whether people will appoint proxies or dummy governance token holders to avoid liability in future or something like that. So everything to play for in this space.
Well, thank you both. I think that there's at least another webinar or two in terms of liability and who's liable and whether people are de facto directors and that sort of thing. So Miles, in about 2 minutes or less, can you, I was interested in what you said. I've got a question here about why the law of mutuals might provide some useful policy steel for DAOs.
Yeah, thanks, Rosemary. Mutuals are international in operation, in that most mutual cooperative statutes are similar around the world. So they're an internationalist sort of organisation, and they also have a code of what it means to be a cooperative or a mutual. And this code is common across all mutual organisations. And it seems to me that many DAOs that I have looked at, not all, have this mutuality about them, and that and an international aspect. And so the law of mutuals and cooperatives and cooperative principles could be applied more readily as a guide to DAOs. Of course, there'd have to be some variations, but I think it provides an interesting pattern or model to look at when trying to facilitate DAOs.
Oh, thanks so much, Miles. Well, I think that might be all we have time for now, but please, Avril's about to set a poll. Please do let us know about your interest in future events. As I said, we're going to run some shorter webinars like this, a longer workshop, and also please let us know the topics that you're interested in exploring. Thank you also to people who submitted questions, and I do apologise that I couldn't get to all those questions. We will take those on board in terms of our future events. I guess I just would note, as was noted before, that it's an area that's moving incredibly quickly. And I think it's very important to canvass the practical issues as well as the legal complexities. So thank you, Lawrence, Joni and Miles, for your presentations today. Thank you all for attending, and we look forward to welcoming you again at one of these events. Thanks so much.